Hey gang, Stephen Marshall, KY at landlordlaw.com. Have a short and sweet update today, but it's potentially an important one. A federal agency, the Bureau of Consumer Financial Protection, has created a new rule that puts new obligations on certain landlords, attorneys, and collection agencies seeking to evict or collect debts from tenants. The rule amends the Fair Debt Collection Practices Act, which applies only to debt collectors, and we'll talk about what those are in just a minute. And I've got a link to the entire rule and the commentary that'll be in the blog post that accompanies this video, as well as a fact sheet where you can kind of get the gist of the new rule in a quicker fashion. If you only watch the videos, make sure you go to the blog and actually check out the posts so you can access these links, because they're not included here at the video. So under the Fair Debt Collection Practices Act, debt has a specific definition, but really it's pretty broad and inclusive. And I'll just read it to you. It's any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance, or services which are the subject of the transaction are used primarily for personal, family, or household purposes, whether or not the obligation has been reduced to judgment. So in layman's terms, if somebody owes you money for a rental transaction where the property was used primarily for family, personal, or household purposes, that debt is covered by the Fair Debt Collection Practices Act. Now, debt collector also has a specific definition. It's defined as any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of debts, or any person who regularly collects or attempts to collect debts owed to another person. Now, that means property managers could qualify as debt collectors if they regularly attempt to collect debts for their owner. Evicting tenants is typically considered the collection of a debt. So we have this new rule. It does not take effect until May the 3rd of this year, and it runs throughout the end of the CDC eviction moratorium, whenever that may be, God help us all. So the rule has two parts, and the first one is a disclosure requirement. It requires that debt collectors that are covered by the Fair Debt Collection Practices Act disclose to their tenant conspicuously and in writing that the tenant may be eligible for temporary protection from eviction under the CDC Order. And the new rule includes sample language that you can use to make this disclosure, and I'll just read it to you. The sample language is, because of the global COVID-19 pandemic, you may be eligible for temporary protection from eviction under state and or federal law. Learn the steps you should take now. Visit www.cfpb.gov/eviction or call a housing counselor at 800-569-4287. So that's the sample language you can use to be compliant with the disclosure. Now, this disclosure has to be made on the date that the tenant is given their first eviction notice, or if no notice is required, the disclosure has to be made on the date that the eviction is filed. Now, the term eviction notice also has a specific definition. It's the earliest written notice that the law requires to be given before an eviction may be filed. So on your non-payment of rent cases, that's typically going to be your notice to pay or vacate. That's when you have to make that disclosure I kind of read to you above. Now, the thing to keep in mind about this disclosure, it has to be delivered as a hard copy. It may not be only electronically delivered through email or text or some other electronic means. You have to deliver it as a hard copy. Now, it doesn't say whether you have to mail it or post it on the door. That's kind of left up to state law on notices. So if you typically post notices on the door, that should be fine for making the disclosures as well. If you send them via registered or certified mail, that should be fine as well. But you may not only make these disclosures electronically. So you may have to change some practices as it pertains to these disclosures. That's the first part of the rule. The second part of the rule is that you may not falsely represent or imply to a tenant that they are not eligible for temporary protection from eviction under the CDC order. Okay, so that's the two parts of the rule. You have to deliver a hard copy of these disclosures, and you may not tell a tenant that they may not be eligible for protection under the CDC. So here's my advice on all of this. Here's the gist of it. You need to assume that you're a debt collector under the Fair Debt Collection Practices Act. That's first. Second, you need to include that sample language that I read earlier on each notice you give your tenant that could result in an eviction. Now, if it's a notice to enter or inspect the unit or something like that, you don't need to include that language because that notice would not result in an eviction. But any notice you give your tenant that says you need to do X or your tenancy is going to be terminated, you need to include that disclosure language. Or any notice to vacate that you give your tenant, it needs to include that disclosure language. That's step number 2. And then step number 3, include that sample language on every eviction that you file. Okay? Now, if I file your evictions for you, we'll have that included. You don't need to worry about it. But if you're filing them on your own, include that on every eviction that you file. Now, does this new rule absolutely require these 3 steps for every landlord and tenant eviction? No. There's a chance you would not qualify under the law as a debt collector. Your particular type of eviction may not be covered under the CDC order. Perhaps it's a material non-compliance eviction, or it's the non-renewal of a lease or a month-to-month tenancy. And those aren't covered by the CDC order, but you don't want to spend the time and money defending a lawsuit to find out whether you're covered or not. It's very easy and very simple to just add that simple disclosure statement on your notices as a way to make sure that you're compliant and you avoid being the test case on these issues. So that's it for today. Short and sweet. If you've got any questions, make sure you reach out to your friendly neighborhood attorney. You can reach me at 859-685-0035 or via email at smarshall@trippleslaw.com. That's it for today. Have a fantastic rest of your week.